Faiza Patel is on the line with us. Faiza is the co-director of the Liberty and National Security Program at the Brennan Center for Justice. BrennanCenter.org is the website. You can tweet Faiza at F-I-I-Z-A-P-A-T-E-L BCJ or at Brennan Center. Faiza, welcome to the program.
Thanks. I'm happy to be here.
Thanks for joining us. So Trump's Muslim ban was argued before the Supreme Court. Was it yesterday?
This morning.
This morning?
Yes.
Great. So what happened?
So basically, you had the justices asking the tough questions of both parties. As you know, the challenge to the ban is based on the fact that it discriminates against an entire religion, that it was intended to discriminate against Muslims, and that was pretty obvious from the statements that Trump made, both as a candidate and then his obvious anti-Muslim bias since he's been elected president as well. So that was really at the heart of the discussion today. So
let's just back up a little bit. The Muslim ban, detail for us the history of this thing and why it is that the Trump administration is not calling it a Muslim ban and everybody else is, and how it got before the Supreme Court.
Sure. So if you recall, back in December of 2015, Donald Trump declared that he wanted to ban Muslims from the United States. That was the first that we'd heard of this ban, and that became sort of part of his regular campaign platform. He was elected president, and within a week he issued an executive order which banned people from 7 Muslim-majority countries from traveling to the United States. You'll recall the scenes of chaos that ensued at airports around the country as people try to figure out what this ban was all about. That ban was pretty quickly enjoined by federal courts around the country, and the administration withdrew it and issued a second version in March of 2017. The second version was a little bit narrower than the first version because it did not apply to permanent residents of the United States.
Didn't they also add in a country that wasn't majority Muslim?
No, that was the third version. That was the third version, not in the second version. The second version, you still had Muslim-majority countries, but it didn't apply to people who were permanent residents of the United States, and there was an explicit preference for Christians coming from the banned countries, which was removed from the second version of the order. But it was, very similar to the first version, and it was again challenged in the courts, and it was again enjoined by the courts. The courts then were proceeding to litigate this issue further, and the government went to the Supreme Court and said, hey, we've got an issue with this, and we want you to review the court decisions in the second version. So the court agreed to hear this, and oral arguments were scheduled for last fall. However, before oral arguments actually took place, the administration issued a third version of the ban. Now, this version was the one in which they sort of shuffled around the countries a little bit. So, for example, they took Iraq, which had previously been on the list, off the list, and they added Chad, which is also a Muslim-majority country. But they also added North Korea, which, as you know, sends a handful of people to the United States every year. So it's not a real
it's meaningless,
the scope of the ban. Yeah, it's window dressing. And then they added a few government officials from Venezuela. So they did add a couple of countries to the ban. They also kind of reframed the justification for the ban and said, hey, we've conducted this big interagency review, and these countries who we've banned from the United States actually aren't very good at sharing information with us. And that was the justification they put forward when they tried for the third time to institute this ban.
So what was the essence of the arguments yesterday, and how, I've heard that the hard right justices on the court seemed, in their interrogation of the attorneys, to be leaning to be more favorable toward keeping the ban, whereas the progressive justices were saying, no way. What's your sense of that, and is that accurate reporting?
Well, I think that, look, when you're talking about national security matters and foreign policy, you are naturally operating in a sphere where courts are more likely to defer to the executive, right? Because they think this is something that the president is better equipped to decide than we are. We don't want to interfere with his judgments. So you have this sort of generalized deference to the executive when you talk about national security matters, which is what this has been framed as. Now, that doesn't mean, of course, that courts have no role, and we have seen courts step forward from time to time in particularly egregious cases to restrict what the executive can and cannot do. And we saw that, for example, with some of the early Guantanamo cases, which went up to the Supreme Court back in the early 2000s. So a lot of this is about, well, how far is the court going to go in looking at what the president says are the national security justifications here. And the government relies very extensively on this interagency process that took place over the course of last summer into early fall. But I think that, you know, at least some of the justices were quite skeptical of that. And I forget if it was Justice Kagan or Justice Sotomayor was like, well, you know, if the interagency knows what outcome the president wants, what are the odds that they're going to come to a different result? And I think that's a really important part of this case. I think the second part of this case that's really important is how do you deal with, you know, a president who has openly expressed hostility towards an entire faith and people of that faith, and then who, you know, puts forward a policy that is facially targeted towards people of that faith. And again, one of the justices raised the question of, you know, supposing you had a president who was a obvious and avowed anti-Semite, and he came into office and with the advice and consent of his cabinet decided to ban people from Israel from traveling to the United States. And I think that the government really struggled with that hypothetical to justify that.
Yeah. So is it your sense that the Supreme Court is going to uphold the travel ban or strike it down?
I think we're going to have to wait and see. As in so many instances, it all depends on Justice Kennedy.
Oh, really? It's that the partisan divisions are that clear?
Well, I don't know if they're that clear, but I listened to the audio because I wasn't able to be there. But from what I could tell, I mean, the justices asked tough questions, and there are tough questions to be asked to both sides in this case. Yeah. But at the end of the day, I mean, I think there is a strong sense that certainly more of the liberal justices are likely to strike down the ban, and the conservative justices are more likely to not strike it down. And you could attribute that to deference to national security judgments, right, which is, again, a sort of a long-standing thing that we've seen in the court, or B, sensitivity to discrimination. And both of those can work in different ways.
I would also attribute a hyper-partisanship on the court, which is, but anyway, Faiza Patel, thank you so much for being with us.